Good evening, everybody. Welcome to our webinar. I'm going to turn it over to Councillor Guy Elliott.
Good evening, everyone. Thank you for joining us as we work through some of the technical issues in this trying time. I believe we have a number of our Cannabis Control Group members present, along with our consultants and lawyer, to review the first draft of our proposed cannabis law for the Chippewas of Nawash unceded First Nation. And we're excited to hear your feedback. I think I will introduce the panel now, and we'll go through sort of the order of the day. And so without further ado, I'll introduce Sarah Mainville, who is a lawyer with OKT. So Sarah, if you could give an introduction to yourself.
Bonjour, everyone. My name is Sarah Mainville. I am also Anishinaabe. I'm from Couchiching First Nation, which is in Northwestern Ontario. I've passed the bar in 2004. I've been working at OKT since 2016. I'm a partner at OKT. And we've worked with several communities on different approaches to cannabis, including cannabis control laws, which we're presenting today, and happy to be here.
You betcha. Next, I'll have Larry Salt introduce himself.
Good evening, everyone. My pleasure to be on the line today with everyone. I'm former chief of the Mississaugas of New Credit. Got involved in politics in 1985 and have been somewhat involved off and on in council. Former Grand Chief of the Association of Iroquois and Allied Indians in Southwestern Ontario. Also held several CEO positions in corporations. Lived in the United States for 12 years and got involved in cannabis basically back in a few years ago when Colorado first broke on the whole issue of medical marijuana, and followed the process right up to coming back to Canada and getting elected back onto my council. Since elected back onto my council at the time, I saw cannabis as a way of being able to generate revenue in our own community and be able to offset jobs within our own process, and particularly our own law. And I'm a pretty sovereign thinker in terms of our own jurisdiction. So we, through the council, chief and council in my home community, we put our own law and our own commission in place in the cannabis the last couple of years. And also of late, I was the co-chair of the National Chiefs Committee on Cannabis. And so I had a pretty good pulse on what was going on across the country. Got involved with Nawash over the last year in terms of looking at the community meetings you've had to date and being involved in the process of helping and advising on this particular issue of cannabis control.
Oh, my gosh. And certainly last but not least, we have our Ogama Chief Greg Najuan and Council Member Nick Saunders in the council chambers. Unfortunately, they're having some issues with the video. So unless one of them smiles, you won't be able to see them through this black screen. But go ahead, Chief. Need to brush your teeth then. Your weed done.
Good evening. Welcome to Greg Najuan, Chippewas of Nawash. And we started a working group to address the new norm of after the legalization of cannabis in the throughout Turtle Island now, including the American side. We want to make sure that when we do walk down this this road, that we have regulations actually for a lot of reasons. One of them is to have the jurisdiction of anything and everything cannabis in our territory, which is from growing to processing to retailing. I know there's been a lot of pushback thinking that we were trying to usurp total power over this initiative, which isn't true. We want community input. Basically, the short story is we want to make this an initiative that right off the get-go is done with method. And that method means having proper regulations in place, adopting our own law, and working with the community as we go forward. So it's just one of those things, because it is relatively a new initiative in a lot of the First Nations, that there are different approaches to how to get it done. And I do believe that we're on the right path. I do believe that reaching out to those that have experience in this area is the right way to go. And we don't have to reinvent the wheel. A lot of the legwork has already been done. It's just putting it together in a template that's acceptable to all. And having said that, I know that in talking with community members and others, that we're all at different places. But it's only through dialogue and working with each other that we'll get to something that's acceptable to the majority. So without any further ado, I'll turn it back to the chair.
Great, Miigwech. Other Cannabis Control Group members not present, and they may join us throughout the call, are Councillor Solomon King, Councillor Sydney Najwan, and Councillor Kellen Wright. So let's get right into it. And Sarah, so I'll ask you to understand that you have some slides that you'll be referencing, and we'll go through each section and review. And I believe there's a way for questions to be asked. Is that correct, Michael?
It is. So we'll let, I'll speak to the panelists and to the attendees. We're going to, let's go through her presentation, and then we'll have some quick questions, I think, and then start going through the bylaw itself.
So Sarah, the floor is yours.
Great, thank you. I'm sharing my screen. I just have to pop it up. And make sure that everybody can see this properly.
So Councillor Najwan also on the line.
Obviously he's not being seen.
So I hope everybody can see this. Michael, if you can just let me know if there's any issues.
That looks great, Sarah.
Okay, so I'm going to start with some basic parts of the Cannabis Control Law, and just what you'll see on the draft document. And you'll see on the document, if you haven't had a chance to review it in its form as the Cannabis Control Law, is it has some notes on it, and it says NTD, which means notes to draft, and it has some explanations. Those are not sections of the law. It's just it's just notes to explain what each of the sections are trying to do. But for the first 4 or 5 slides, this is actually what the law says, and this is the preamble of the law. Preamble meaning that it's basically background information that helps in the interpretation of the law itself. what is the law trying to do? And these are the reasons why the law was put in place. And so the most important thing is we're trying to address matters of public health, safety, and security. And by creating regulations, you create more opportunities for economic development, and you take away some of the barriers that we know might happen if you exercise jurisdiction in an unplanned way. And also to confirm that the First Nation is using their inherent jurisdiction beyond the Indian Act. And this jurisdiction is confirmed in international law through those through the UN Declaration on the Rights of Indigenous People, as well as Section 35 of the Constitution Act 1982, as well as Sections 2, which gives the First Nation Council authority, as well as it recognizes their inherent authority under Section 2 of the Indian Act, as well as Section 81 of the Indian Act, which is a bylaw making power. But actually, the Indian Act now calls these laws and does not use the word bylaw anymore. So the purposes too, I'm going to just highlight them because the purposes are not unlike the purposes of the Federal Cannabis Act. And one of the things that we know is from the viewpoint of Canada is that they recognize that First Nations do have jurisdiction, but will have issues with jurisdictions that go to cross purposes, meaning that you're trying to do something that the Cannabis Act is trying to do, and you're trying to stop it. And so we try to stick with the same purposes: health, safety, and security of the First Nation, controlling access, particularly controlling it away from children and young people, putting appropriate restrictions on in-community cannabis use, and regulating the sale of cannabis through a system of licensing. And the most important question, I think the chief had spoken to this, was, why have a cannabis control law? One of the most important things is because Ontario also has the regulations, and they purport to say that their rules apply to the First Nation. But under the principles of federalism, which is a legal term meaning that provincial laws don't apply when under this principle of federalism when you cover the field. And so you oust Ontario rules by having your own law on the reserve. This is part one, this law, and it's meant to be sort of the standard and framework of regulations. But there's also a part two that's forthcoming, and I'm hoping to hear some comments and some ideas from the community so that our regulations are the particular rules that follow enacting a commission and enacting a licensing regime. Some particular rules and ideas are shared by community members, and we can put them inside of a regulation. Another important part of this is that it's not chief and council that's doing the licensing. There is going to be a commission or an independent authority that will be the licensing authority under this law. In addition, we also recommend that the chief and council leadership and experts engage in without prejudice discussions with Ontario, because we know one thing for certain is that if Ontario does recognize your licensing, that there can be business-to-business relationships between such entities as the Ontario Cannabis Store, for example, which is a big market for cannabis if you're a cultivator, but without recognition by Ontario, the Ontario Cannabis Store cannot do business with Nawash licensed cultivators or producers. If you're producing edibles or such, you couldn't do business with Ontario Cannabis Store without recognition by Ontario. Canada may also observe discussions with Ontario and also may get involved in helping your businesses if they do recognize the Nawash jurisdiction. We, through experience, think that the time frame is at least 6 months to begin licensing. So once the law is up and in force and the commission is in place, and there's a training period for them to make sure that they exercise their authority properly, there's about a 6-month window for that all to happen. The question might be, why a Cannabis Commission? I think it's important, and it's something that we've talked about with the task force of the committee, is that there should be separate political and licensing decisions involved, and that's why you should have an independent commission. The commission also grows in capacity, and they become the experts on how to best control cannabis and also to foster economic development, which is really important. The commission members are the decision makers. The first slate of commission members are going to be appointees, just to ensure that the commission is gets a good start and makes good headway in the beginning. There will be appointees, but in future there will be elections of commissions. So the commissioners themselves will be independently elected and therefore have more independent authority away from chief and council. In addition, the commissioners can contract agents to complete inspections or investigations. It's not contemplated that commissioners will be going out and investigating the retail stores or the distribution companies or the producers, that they would contract agents to do those things who have special training in investigations or inspections. So this is sort of the picture, and I'm going to stop after the next slide, but this is sort of the overall picture of what we're trying to do by creating a system of regulating cannabis in your community. We know that the two challenges are to have legalized outside supply and having the world recognize that it's legal outside sales, meaning as soon as a customer leaves your community, that there's no type of enforcement activity that sees that product is either gray or black market product. So we need to put a system in place that is both legal, meaning that there's a law behind it, but also seen as legitimate. And legitimacy is going to be impacted by black or gray markets interacting with your system. So our advice is that at some point in time, be it a number of years, that there will be no black or gray markets interacting with the Nawash legal system, that you become self-sustaining. So these other outside influences, is that me that's echoing?
No, not you,
Okay.
Sarah.
Okay. Okay. So if everybody please go on mute if you can. I think there's an echo coming from somebody else. So the outside influences are the capacity of the community, gray, black markets trying to become part of your system. And we'll have, I'm going to highlight some regulatory aspects that try to keep those gray and black markets outside. You also want to make sure that your businesses can actually receive business services as a legitimate business, so that they can do banking, they can get insurance and things of that nature. So that recognition by other governments could be important, but also recognition by just the business sector would be important as well. And then there's other outside issues about enforcement and policing and recognition of your licenses. So those are things that we try to work out throughout our advice as we drafted this law. So this is the last slide before we go into the initial questions. Within the law, the procedure is that all suppliers, this is outside suppliers, must be approved by the commission. And all products that go on the shelves of the retail stores must also be approved. And that's under section 47 of the law. And again, the procedure, the first order of business once this becomes law would be to put the first commissioners in place. Those would be appointees of the band council, and then to have the 4-year time frame to have elections of commissioners in the future. Once they're elected, they're considered more independent, or probably will act more independently from the chief and council. The licenses are 3 types: retail, sale, distribution, and production licenses. The commissioners are the decision makers, and there's aspects of procedural fairness inside of the law. So there is an appeal committee as well inside of the law. So if there's any questions up to this point, I'd be happy to answer any general questions.
This is Michael. So if any of our attendees or guests on the call have a question, if you put your hand up, and I will recognize you to ask a question. I saw a hand there for a second. Did someone change their mind? Okay, so no questions at the moment. Let's move on then.
So there's quite a bit more detail, so there might be more questions when we get into the details.
Of course.
So the application of the law is that it applies to all cannabis activities on the reserve, generally, but it also gets restricted in two more ways, and I'll highlight that as well. The application applies to any federal or provincial licenses. So for example, if a producer also wants to have a Health Canada license in Nawash, they also have to have a Nawash license. So you'd have to have both. And actually that probably would be preferred. We've had discussions about this, but we can get into more detail on that. There is a harmonization requirement, or not a requirement, harmonization, openness for harmonization with other laws. But to me, more restrictive, this law is not about regulating medical cannabis. So if an individual in Nawash does have a medical cannabis prescription, and they get that from a licensed medical practitioner, that all prevails over this law. We're not intending to regulate that. Also, if there's a conflict between this law and provincial or federal laws, this law is meant to prevail over those laws. So we would hope that anyone interpreting this law against others would see that this law supersedes those other less local laws.
Hi, Sarah. We have a question. This is actually coming from the chief.
Okay.
And Chief, if you want to go ahead with your question, you'll have to unmute your mic. Or you could type your question in and just let me know and I'll pass it along. Okay, so let's proceed while they work that out. Chief, I'll get you to look through your settings there to find your unmute button so we can either hear a question or you can type your question into the chat and I will pass it along.
Sounds good. So one thing that we were told to be clear about is that the community, the leadership strongly believe that the Anishinaabe have an inherent right to personally use traditional plants, herbs, and medicines for food and ceremonial purposes. This law does not purport to interfere with the rights of members to use plants, herbs, and medicines for food and ceremonial purposes. This purpose of this law for greater certainty is to restrict cannabis use for recreational purposes to persons 19 years of age or older, and to provide a legal framework for the production, distribution, and retail sales through licensed commercial activities. So we are not trying to touch those personal or ceremonial purposes, medicinal purposes of cannabis with this law. And we want to be clear about that, and that's section 11. I also want to, and I know that the chief had also mentioned this was kind of a concern within the community that the leadership was trying to take opportunities away from the community. There definitely is a partnership opportunity, and I thought is my advice, an important opportunity that could be captured in the law is a recommendation to have a First Nation business jointly owned or community owned that would be the distribution company in the community. That's only there is an opportunity or a doorway to do that, but it doesn't mean that the community or the commission has to do that. It just affords that opportunity. It also does something for me as far as being your legal advisor, is that it's one doorway in as far as the products and the suppliers, and therefore it's a way to enforce everybody being licensed and all the products being licensed is having one doorway. But that's something that we can hear from the community. I think it's an opportunity for a business to get started, but we'll have to have discussions with the entrepreneurs that are interested in getting involved in cannabis on where they plan to get the products from, and if they can afford for this distribution company to be a middleman or not. We know in Ontario, in several other provinces, there's one distribution company. In Ontario, it's called the Ontario Cannabis Store. And it definitely has its issues, but it certainly does make sure that all of the products are all licensed and all the shelves are only full of licensed products. And it's a way to enforce and police and inspect without a lot of sort of overly zealous regulatory efforts by having one distribution company. But that's something community can tell me is a good or bad idea. I certainly think it's a big opportunity for economic development. So that's another section I want to mention, that it's an idea that comes from your legal advisor. It's not something that leadership necessarily is convinced will work, but definitely I think there's an opportunity there. We also want to highlight before going into the section by section review that there's some important advisory jurisdiction. As far as production, like if you're going to produce a lot of cannabis, it may be too much to have only sales to retail stores in the community. So it might be advantageous to have licensing that allows you to sell to an entity like the Ontario Cannabis Store. That would mean that you would have to be Health Canada licensed, or that you might be licensed by other First Nations. I've done 2 laws so far where the First Nations are licensing outside businesses to distribute or supply their stores. And so those things are happening in First Nation territories, maybe not widely known, but definitely I'm a big fan of these things being regulated and licensed as opposed to not being regulated, and or this term self-regulation, which I think is a misnomer. We try to give some advice, re-jurisdiction, especially if you're a producer. The Nawash market may not be large enough to be a large producer and expect there to be enough sales in the community to be solely licensed by Nawash. And also the last bullet, the harmonization, it allows discussions between Nawash, First Nation, and other governments. And that recognition, again, would be advantageous for increased markets and to ensure that customers coming from outside the community, there's no enforcement issues once they leave the community. So I'm going to go into the different sections now. I don't know if the chief is able to ask his original question. If not, I'm going to go into the prohibitions section.
I think you can proceed, Sarah. Okay.
So the prohibition section, and this is 2 important parts of the consultation within the community, is that I sent 28 questions, which were basically the big policy questions for this law. And one of them was the restriction in age, and the decision was to do like most jurisdictions have done, is said that the age has to be 19 years of age or older. Again, the federal government, their restriction is 18 years of age or older. So that's a policy choice that we certainly want to hear comments or any issues with that age of 19 years. There's also 2 limits or restrictions in the law about how much the quantity of cannabis a person can hold, and that's 30 grams. So that's very similar to the Federal Cannabis Act. There's definitely risks for going higher than that, but 30 grams was the policy decision made, is the limit of cannabis you can have on your person, and also 4 plants per household. So not unlike the Federal Cannabis Act. Both of those limits are in the law, but we definitely would like to hear if there are concerns or issues with those limits and those prohibitions. If there's no questions on that, we can go to the next section.
There is a question.
Okay.
Do you have the chat in front of you, or do you want me to read it out to you?
Oh, if you can read it, I don't have to leave the slide.
Okay. So Lance Johnson Reyes asks, how has this document approach worked in Tyendinaga?
So Tyendinaga, like the other chief and councils, I gave the policy decisions to leadership and to task forces. And so it's definitely a totally different approach here. The policy decisions are different. So this law is a different approach in some policy areas because I'm a lawyer. I don't have a template law that I'm shopping around. I ask the policy questions to the communities, and the communities decide. I truly believe in self-determination, and so the decisions, if you compare the two laws, they're quite different in approaches.
And a follow-up question says 30 grams is the federal policy. However, there are no limits to how much you can come back.
That's true. This is part one again. So part one is the law itself, and the regulations can put other rules in place, like frequent customers that frequent stores more than one day, and so those are important decisions for the commission to make, but the law itself does not put limits on that. So the 30 grams again, we're like, if the member wants to make other suggestions as far as limits, that's a good thing. Again, we're also trying to meet two other goals, which is to keep black and gray markets out, to make sure that the products don't get in the hands of children. So allowing sort of unlimited purchasing power of all the customers could pose other problems as well.
Thank you. That's all we have for now, if you want to continue.
Okay. So I'm just have the highlights of the rules, the law framework, the legal framework around the commission. So this is sections 13 to 17 in the law. So, the marching orders for the commission: administer the law in the First Nations' best interest, work consistently with ban policies, have high standards, be impartial, be independent, hold integrity, be transparent. The commission will have to create their own budgets for approval by the Ban Council. This will ensure that fees and remittances are budgeted and budgets are spent both with transparency and accountability. A regulation will set up other procedures and measures to ensure that the commission is accountable directly to the community. And the commission is supported by two revenue sources: license fees and remittances. And I have more detail on that in another section. I see there might be questions.
Yes, the question is from Councillor Sydney Najwa. How do we address cannabis as a food?
Is a food. So this is back to section 11. I don't know if Sydney was there for section 11. I can certainly flip back to section 11. So this law is not trying to regulate cannabis regarding its use, personal use for food or ceremonies. So we are not trying to regulate that. Unfortunately, there is a federal cannabis law that applies on the reserve, but hopefully the federal and provincial governments will work with your leadership to ensure that they ask first before they enforce that Cannabis Act. But this law does not purport to regulate cannabis for personal purposes, such as food or ceremonial purposes.
We have a question again on that theme from Lance Johnson Reyes. What qualifications or experience do counselors have to judge a product's eligibility?
The commission is the the licensor. So the licensing authority. So it will be the commission, the members of the commission who have a certain expertise, I would hope. I would suggest that the task force does a skills matrix to make sure that the three commissioners do have certain expertise about the different products. The most important thing I can say to someone like the person that's questioning is, if they can be as transparent as possible about where they're getting the products. We're trying to create a system that accommodates them, but also to make sure that this legal regime is seen legitimately and recognized as a legitimate cannabis authority by other governments as well. So let's talk about those things. One of the major issues that we have is if there's a black market source. I'm friendlier towards what I would consider gray markets under Indigenous authority, but black markets would be a difficult thing to legalize. If it's a supplier that is, selling on the black market to individuals, it would be hard to legalize them as a supplier, but let's talk about that.
A follow-up question. Is it not council being appointed to the commission first?
No, the council is appointing the commissioners. So the idea is that there'd be a general call for individuals that are interested in being the first commissioners, and there'd be an appointment process where you'd probably try to reflect the skills matrix in the three people that are chosen as commissioners.
No more questions right now.
Okay, so that's the commission. And the commissioners themselves, and this is highlighting sections 18 to 27 of the law. There are 3 members, and amongst the 3, they would choose their chair. The chair has additional responsibilities. The appointment process, I think there would be a discussion, and we certainly want to hear from community members of how long this initial term should be. I would suggest that it should be at least 2 years in order to take advantage of any capacity or training that the people take, and then having elections for 4-year terms afterwards. And we could talk about adjusting or having different types of terms, but for each commissioner would hold a 4-year term. The commissioners must be band members. And we can have a discussion about that as well, because not all commissions or boards under these laws are band members. Some are outside experts. And the only way commissioners can be removed by council is for cause, meaning that they're acting unfairly and there's enough cause to remove them. There's also a responsibility of the individual commissioners to give at least 60 days notice if they're deciding to resign. There's a by-election held if there's a vacancy. Again, the commissioners have the ability to authorize agents to act on their behalf. It's not expected that each of the 3 commissioners will be doing the inspections and such, or the investigations under the law, that they would actually have agents who are experienced and able to do those types of things. The initial commissioners, again, are appointed by council, and it's not, I don't think, in the mind of chief and council that they themselves would be commissioners. Is there any questions? So these are the rules of the commissioners.
We have no questions at the moment.
So there's a bunch of rules about having meetings that are transparent and accountable. The 2 main points under this is for sections 28 to 36 is that the commission will need to protect the business and operational plans of applicants for cannabis licenses, so that some of the information and some of the meetings will need to be confidential and not open or available to the public. But for the most part, the meetings are supposed to be public for accountability and transparency. But again, there's a recognition that there is important marketing and business information that needs to be shared. and the commissioners have to go through them and discuss these things and keep them private for the business interests of the applicants. The chair's specific responsibilities are to make sure that there are monthly meetings, chair the meetings, schedule the meetings, give 5 days notice, establishing quorum of 2 members, voting and decision making is done responsibly and transparently. So those, that's the specific sections around the meetings of the commission. I don't know if there's any questions about this. It's pretty general and uncontroversial. Now we get into the more of the details and the nitty-gritty of the law. And here are the rules about the licenses. So this is section 37 to 40 of the law. So this may be controversial, but it is in the law that the commission can give up to 5 licenses to be issued at once. So it could be the very first meeting, they issue 5 licenses. They can create regulations that allow them to consider granting more than 5 licenses, but it will all be regulated. So there will be different conditions and terms that would allow them to grant more than 5 licenses. The license holders themselves, and this again, we're getting into potentially controversial areas because these are policy decisions. Some of the 28 questions I put forward to the Chief and Counsel. The license holder must be a band member. They must be at least 21 years old or older, and they must be a resident. And again, we would love to hear comments about those 3 requirements. I know residency itself, we've given advice that that might be a problem to limit this opportunity to band members who are resident. And so would like to hear your comments. And certainly I know the policy reason why you would want folks to be resident, because they should be living in the community and deal with the impacts that they're bringing to the community as a resident of the community. And certainly there are municipalities that require certain business owners to be resident, and that's not that controversial. Another thing, and this goes to the idea that we want to keep organized crime out of the system, is that all owners must be part of the application. So there can't be any silent partners that are not also part of the licensed application. That could be a reason to suspend or to revoke a license if all owners are not part of this application. All managers must also be listed on the license, and that's about the terms and conditions of the licensing. More rules may be made in regulations by the commission, and the commission may inspect proposed sites to be licensed. So there probably are questions about this section 37 to 40.
Yes, well, we're going to back up a little bit. We do have another question from Lance Johnston-Reyes asking, what is the eligibility criteria to make the commission? I think he's asking what criteria makes a person eligible to sit on the commission.
I'm suggesting that there be a skills matrix used for what kind of skills you'd want to be on the commission, but beyond being band members, the eligibility is you know, it's very limited. 4-year terms, there's no term limits, but you must be a band member. Other than that, I think a skills matrix would be helpful to ensure that you have the composite skills that you need for this commission to work. Would probably be helpful, but it's not in the law.
We also have Councillor Elliott had some questions as well.
Yeah, I just wanted to back up to the harmonization section, if you don't mind. Larry, maybe this is directed at you, but could you speak a little bit more as to maybe some of the advantages and or disadvantages to the harmonization that's described in that section with respect to relationship with, say, the province or the federal government?
Sarah, do you want to talk about that from a legal perspective? I'll talk it from more of a practical perspective.
Sure. Sorry.
On the harmonization question, we were talking about the superiority of the First Nation law versus federal and provincial harmonization with our laws. And so maybe from a legal perspective, you can talk about that. And my whole question has been, if I am a federally licensed First Nation cannabis holder, can I work with Nawash to produce products for them? So there's that's that whole harmonization question.
Sure.
Other than the things that you said, First Nation to First Nation, but also if I'm a Health Canada license holder, I can produce, I can do all the things and supply Nawash or any other community as long as I am federally licensed.
Sure. So one of the things that I know for certain, because I've been involved in different discussions with Ontario and Canada specifically, is that if they don't see a section in the law about cooperation or harmonization, that they don't feel like they have, feel like they have a doorway in to talk with the community about any sort of dual recognition, Nawash's recognition of their law and other governments' recognition of your law. So the harmonization section is just required on that basis. But I think also that there are real restrictions in operating solely under Nawash's law without any harmonization or recognition from other governments. Namely that your market will likely be restricted to inside the community, and without recognition, your customers may have issues, mainly with taxes, but with other issues once they leave the community. And
one of the other questions that one of the other comments that I made was the question of putting together the task force, if you will, or the working group made up of the Health Canada representative, OG, the Ontario Gaming and Attorney General's office. Those were what I was talking about when we talk about harmonization and sort of preempting what we want to do from the business perspective. So we bring all them players together and start to hash out how we see that rolling out on behalf of the First Nation. Sarah,
Right.
did you want to comment on that?
Sure. So if you do have a table where you're talking about harmonization, you will have from Ontario, you will have the Attorney General. You'll also have the Indigenous Affairs Ontario folks there. You'll have Ministry of Finance folks there talking about how to deal with jurisdictional complexities like tax, enforcement, business-to-business relationships with the Ontario cannabis store, if that's something that you want to do, business-to-business relationships with licensed producers, if that's what you want to do with Health Canada. And those discussions are part of the agenda. Potentially will find themselves in a legal agreement or an MOU maybe between those governments. And that's something that you can, literally bring to the bank or, to other business services sectors to see that you're recognized as a legitimate licensed business, and you can do all those business arrangements that any other licensed business can do.
I guess along the same lines, Sarah, maybe a question for the chief and council would be, when should they initiate, if that's a course they want to take, when should they initiate those discussions and starting to pull that team together?
I always think that there's an opportunity when you can be the first in the door to sign an agreement. So being the pilot that develops this agreement, that there's been stops and stalls in different First Nations that I've been working with about those discussions. So I think if Nawash is going to set the standard, then you have more capacity to establish precedents. But once someone puts pen to paper and has an agreement, we're kind of stuck with that as a precedent. So there's an opportunity now for sure to do that, less of an opportunity once another community signs an agreement, we'll be stuck to many of the same terms.
We have a question from Councillor Sidney Najwan. If more than 5 licenses are required by the community, is 5 set in stone?
No. So that's, I think one of the things that this is sort of a cautionary approach to the law, meaning that certainly there can be regulations to create sort of what you need to see in the environment to have more than 5 licenses of any type. And also, I think that it's a real problem, especially in cannabis. I mean, and maybe because they sound similar, cannibalization of market opportunity is a strong, strong problem in the cannabis arena. And so it's sort of cautionary that there's only 5 licenses, but certainly there is room through regulations to create more licenses.
Thank you. That's all we have for now.
So the commission will make the decisions to license, and this is the legal framework for those decisions is under section 42 to 46. As the commission makes decisions about applications and application renewals, there must be fairness to the applicants. The commission will need training to advance this aspect of procedural fairness. The commission may decide the conditions of the license, may require some training. I know that there's one product that people know called CanSal. I don't know if any indigenous companies are creating specific cannabis training that's maybe better to deal with Nawash stores, but deciding which training, which policies are required in the terms and conditions of a license will need some capacity and some training of the commissioners. One of the strong rules is that the license holder must be current. So with any fees or remittances that they owe under the licensing regime, they have to be current with them in order to get a renewal or to get a license. It has to be in good standing and to keep the license throughout the license period. They need to stay current with their remittances and any other associated fees. So if there's questions, there may be questions about the licensing decisions.
Not right now, no.
Okay. So maybe there'll be some now because this is a note about the remittances. So the policy choice was that it's around 5% is the normal remittances for licenses. Again, the actual rules around this is going to be in a regulation. It's not. The remittances are allowed in the law through one section of the law, but the actual how the remittances will be calculated will be in a regulation. We certainly want to hear comments from entrepreneurs about how this is going to work. I know that I myself is a partner of a law firm. I'm a business owner, so I know that too much taxes is a problem. And so license remittance fees as a cost of doing business can't be too high. So there's a consideration in the policy decisions made by leadership that volumes and sales for smaller businesses may be consideration of a lesser amount. The commission itself will establish the rules without exception. So the rules have to be both clear and fair. And for this to work, due diligence and transparency will be required by the licensees. So the license holders will need, to do their job in making sure that they're remitting the proper amounts, and so that the commission can continue to work and to shield and protect the license holders from enforcement by other governments. And because this provides a benefit for these license holders, the system is established for them. Therefore, they also must pay for the system. And that's why the commission is paid by 2 revenue sources: the license fees and the remittances. So I'm assuming that there's no questions, but definitely can come back to this. So there's a very long section, section 47, about the terms and conditions, and here are the highlights. The licenses are for 5 years, and you need to pay the license fee, but also the remittances throughout the year to be in good standing. All customers have to be verified to be 19 years of age or older, really important rule. The customers cannot be intoxicated to be served. Retail sites are licensed, and therefore all purchases must be made at those sites only. There's going to be approved suppliers and approved products. I think, and you sort of in the outset of this, it's likely going to be, you know, a bigger process than will be in future years, because I suspect that there'll be similar suppliers, and you know, as First Nation jurisdiction becomes more of a market, you're going to see more suppliers just choose to work for First Nation businesses, and therefore there'll be some really good suppliers. Not that there isn't already, but there'll be some really good suppliers supplying First Nation jurisdictions, and the approval process, therefore, I think will be less burdensome. The Commission will provide a retail seal, and that's a sign to give the product both to be seen as legal and legitimate legal cannabis product in Canada. There are other conditions. So there's a list of prohibited places, and that's park, library, school, playground, community and lifestyle center. So the 150-meter radius, so there cannot be any retail stores or production facilities within 150 meters of these places. Residential areas are also prohibited, and the regulation may prohibit other areas where children and youth will frequent in the future. Those are not listed yet. So I think that's probably not that controversial. Again, one of the main goals is to keeping cannabis and cannabis culture away from children and youth. The next sections are about the appeal committee. Again, this is about the importance of procedural fairness in your law. And there can be an appeal within 30 days of the Commission's decision. And beyond those 30 days, the Commission also does have discretion to have a later appeal. Investigations are done by agents of the Commission, and the rules for those investigations to be done fairly is under sections 53 to 58 of the law, with some procedural fairness protections for the licensee. There is to be an oral hearing to determine if allegations are true, and the Commission will give written reasons, and that's section 62 of the law. So procedural fairness inside of the law to protect the licensee's interests. If there's no questions. This might be of interest to people, is the remedies in the law. So the remedies in the law is being licensed, are not being licensed. It's really, the law itself is the enforcement mechanism to be licensed or not. So most of the rules are around that. One of the remedies is simply a warning. Another remedy is amending the license, creating more terms and conditions, or stricter terms and conditions. Revoking the license is also a remedy. Suspending the license for a period of time is a remedy. Prohibiting named licensees from being licensed over a period in the future is also a remedy. There's a fine of up to $100,000, and of course I need to explain that. First offense would likely attract a smaller fine of $5,000 or maybe even less. Again, depending on the regulations that are drafted with the Commission, just some expertise and some stakeholder involvement in what are the appropriate fines. Again, this is after oral hearing, so they would also hear about the ability of the licensee to pay substantial fines. and also just allowing any other remedy consistent with this law. So those are the remedies under Section 63. I don't know if there's any concerns or questions about Section 63.
Nothing's being asked. Carry on.
Offenses, and again, this is when the commission has determined that there's a breach. So this is after an oral hearing and making sure that the decision isn't appealed. There could be up to $100,000 fine, again, with that same explanation that it's unlikely that that would be the first offense, or not a very serious offense, would be a much lesser fine. Up to 30 days imprisonment, again, well, and also the band council might also obtain an injunction if there's something happening that could prejudice or in any way can hurt the jurisdictional, the exercise of jurisdiction in this law. So those are things that could potentially be in a court, a Canadian court. And I know that there are concerns with that just generally, but we need to provide some certainty of what is available as a means of enforcement beyond basically within the licensing regime of losing the license or having a license suspension or things of that nature. These are enforcement mechanisms beyond that, just to ensure that there's compliance with the licensing regime. Section 71 and 72 are long lists, and these are basically the regulations that the commission can make for itself.
Hello, Sarah.
Yes.
It's Chief Nadjuan. When we're delving into this initiative with the end goal is to take on the jurisdiction of the cannabis, everything cannabis. Has it ever been suggested to be singing off the same song sheet as far as laws go to implement restorative justice as instead of going into a town court scenario?
Yeah, I think that that's one of the things that other laws have created are, especially for youthful offenders, is to allow sort of a more restorative justice regime deal with anyone under the age of 25. And we've had sections of the law. Actually, I think the Tyndall law has a section like that in it. But they're potentially how you can create that in here is on the actually there's no list here, but creating a regulation that actually allows the commission to do that. But the other thing that your chief and council doesn't have that some other communities, Anishinaabe communities have is sort of an administration of justice law, where they have those requirements that prior to considering enforcement in Canadian court, that they consider the ADR or restorative justice.
Thank you.
So I was just mentioning that this long list under section 71 and 72 are the regulations that the commission are allowed to make for themselves. Again, it would be prudent to have stakeholder consultation on such things as standards for the retail sites, the forms and procedures for the license applications, talk with people that do investigations or have knowledge about proper investigations, to do the procedure for conducting investigations, things like of that nature. But certainly the commission is empowered to set these regulations. One of the regulations will one of the regulations under D is going to be the list of approved suppliers. And it'd be interesting to know whether or not you think that is sort of business information that should be kept confidential and private or not. That would be interesting to know. I don't know if that is sort of marketable business information that should be protected for each of the retail stores that want to open, who their suppliers are. But that's something that the commission should know.
Hi, Sarah. It's Michael. Not to get too technical about this, but perhaps you could explain to our listeners who don't have your wealth of legal training, the difference between this law itself and a regulatory regime that this law enables.
Sure. So the law is the legal framework, and it's the important rules that the commission must comply with. So once this law is passed, this is the marching orders for the commission. They can't change those rules in the law. But the regulations themselves, and that's why they're set up, certain areas are set up as regulations, is the commission has to have some powers to create the proper rules. And again, I think one of the things that I've heard was that we want to create economic opportunity here. So there are certain rules that may have to be fixed. And it's hard to change a law once a law is passed. And therefore, we put some of the subject matters within the regulations to try to allow the commission themselves through their rules, upholding standards, of course, and making sure that we meet the goals of the law, which are most important: safety and security of the community, but allowing for some economic development here by creating some regulations that do encourage investment in this industry. So the regulations can be changed. They'll be created by the commission. There's requirements to consult stakeholders and to consult the chief and council prior to enacting them, but the regulations can be changed by the commission.
Thanks for that. That helps me. There is a question from Lance Johnston Rays. How are their regulations being welcomed by the communities in Wanapitei or Tyendinaga?
So Tyendinaga, I don't know if people know this, they probably don't know this, is that there was a referendum on Tyendinaga's law, and it, for many reasons, it did pass, but it only passed narrowly. And one of the main concerns that the chief and council of the day heard was that there wasn't enough consultation about it. So we didn't get into phase 2 with them on the regulation components, but certainly their law had a lot more regulatory rules in it. And because there was also already a cannabis industry, I mean, frankly, what I heard from some of the entrepreneurs is that they didn't want rules. And so I would say that they were very much opposed to rules, and certainly opposed to any kind of remittance or sharing with the community. That's certainly what I heard loud and clear from the entrepreneurs that are already involved in cannabis in Tyendinaga. Wanapitei, the stakeholders, one of the key stakeholders are the store owners, and they are working with the chief and council to create the proper environment, and certainly are being brought through along the way. And I think they're much more supportive of it because they want that shield. They want that protection of the chief and council licensing them.
Thank you for that. There was a follow-up question, but I think you've addressed it, and that was, how have similar bylaws and regulations worked out for those communities? And I think you gave 2 examples, one where you didn't proceed to phase 2, and the other one where you had a more hand-in-glove working relationship between the vendors and the council.
Yeah, I mean, to be clear, there is not there's one licensed store in Ontario in a First Nation, and that's the First Nation owned Thessalon store and it's licensed through a BCR. And frankly, I don't think that's enough. Like if the provincial federal government wanted to enforce against them, I don't think that BCR would withstand scrutiny. It would be much like Pamajuan 2, if you remember that gaming case in 1997, where you had to prove an Aboriginal right to regulate gaming. You would also have to prove the Aboriginal right to regulate cannabis. Very, very difficult jurisdictional challenge. You have to do a lot more legwork than a BCR to oust already in place provincial legislation. So, I mean, I think that some of the entrepreneurs are doing themselves a disservice by saying that self-regulation is enough, because clearly it's not. It is not enough. It will not withstand a jurisdictional challenge. You know, I've read all the literature. I get all, you know, the dispensing freedom literature, and I've never once seen an actual legal argument inside of them. I've seen a discussion that there are legal arguments, but I've never seen the legal argument that these folks have, because they don't have one, frankly. I have one last slide, and that's the fact that this is a law that becomes enforceable once it is approved by Chief and Council and gazetted. I think that's what we want to do here, is put it in the First Nation Gazette. And once it's posted there, it becomes enforceable. But again, this process I think is a very good process, is to show that the law has been discussed in the community with community members. We hear your issues and your concerns. We might change the law to reflect some strong concerns. That's the best way to show that the law, in fact, reflects the will of the people. And that's how law becomes law, certainly in Anishinaabe. Nak'nagewin, the will of the people reflected in Anishinaabe and Nak'nagewin makes it law. And that's really important process. Is chiefs say in my area, you have to do these things openly and in the light of day, and that makes it stronger law. And I really enjoy being part of these discussions, and look forward to hearing any comments and concerns about this, and reflecting those comments and concerns in any redrafting that we do. Miigwech.
Oh, miigwech for that overview. I just had I guess a comment and maybe a bit of a question. Just there's a lot of reference to Tyendinaga and other markets, given you know that those have been active markets. Nawash is quite substantially smaller in terms of population base and in proximity to urban centers. On the points earlier raised, but with harmonization and I guess striking a deal with the province and the federal government to acknowledge one another, but that our law supersedes theirs, and you know that would be quite a process. Could you speak to some of those conversations that have already taken place and where they fell down? Because you know, if Nawash has an opportunity to sort of be a front runner in negotiating a deal, it would certainly, I think, be in the interest of many community members, especially the entrepreneurs, to expand our market base, not only just on reserve, but in our territory, which is quite expansive.
Right. So I don't want to be too critical about a lot of the entrepreneurs that have tried to fight leadership from taking on this jurisdiction. And I've met Del Riley in the past, and I certainly don't agree with him, but I respect that, you know, he's trying to make a living and espousing himself as a Section 35 expert. But I don't agree with him at all in his denigration of chief and councils is solely having Indian Act powers. And that's definitely taking a big bite out of the success of, you know, how some of these jurisdictions certainly can enrich themselves and create more opportunities for themselves by creating First Nation trade and commerce. And that's people like your consultant, Larry Salt, and other folks have tried to have these discussions around cannabis. Unfortunately, you know, a lot of the movers and shakers also have business interests, so they find that they can't talk openly about what they're actually doing with cannabis. And that's unfortunate that we can't separate the political from the business. But I think there are some communities, I think Wanapitei is going to be very successful because they've found, you know, they've moderated that discussion. They've had an adversarial relationship between the business owners and the chief and council, and they've resolved that, I think, and they have an inclusive process now that includes both. And now, power of the people, you know, the law is going to reflect the will of the people. The entrepreneurs' suggestions are being heard and listened to, and I think the law is going to be more suitable to economic interests. So probably a success story. Then there are other communities that have created markets. I mean, Alderville is not that close to Toronto, but Toronto drives in droves is a market to Alderville, just because of the superiority of the products that they created. And they may be, in fact, a supplier of some of your stores or the entrepreneurs that want to open stores in the community. But yeah, the quality of the product is certainly an important aspect of creating a cannabis industry. Unfortunately, that's something that the Ontario Cannabis Store has failed to do. The product that they provide to the cannabis stores, the licensed Ontario Cannabis Store by the AGCO, have inferior product on their shelves, and they're too expensive. And that's why the First Nations do have an opportunity to create markets. And,
Sarah, one of the things that we, you know, that we've discussed, and I think Guadan's talking from the perspective of having a facility store on reservation on the First Nation territory and one in the treaty lands. In our case, it was at the Mississaugas of the Credit and downtown Toronto. And how does this harmonization question deal with having both? Superseding the law on the territory, we just do it, but in downtown Toronto, a little different story. Is that clear, Guy Waden, that you were sort of getting around to?
Yeah, absolutely. I think, you know, with our land claim soon to be resolved, I think it could create that opportunity if we do have a favorable ruling. But, you know, we should always try and open up larger market space for our entrepreneurs in the community to help support them.
yeah, I mean, the one thing that I've had conversations with licensed producers about is kind of the idea that First Nations actually can be the innovation market for them to try out things if, you know, they can find a way to do that through creating different businesses that can actually invest in First Nations, and their willingness to work with licensees, especially if they have ongoing discussions going on with Ontario and Canada. That gives them sort of an umbrella from, you know, controversial, like people thinking that they're going outside of their own licenses with Ontario, Canada, by knowing that Ontario and Canada is talking to these First Nations and trying to create a regime that includes them. So yeah, so there's different ways of trying to capture larger markets for your producers and your retail stores for sure. The one probably important for your community members to know is the one thing that I've advised against, because I just can't think my way through a legal way of doing this, is an online store. It's too novel, and it's Section 35 is just too, the tests under Section 35 are just way too difficult to lose that land aspect and having an online store. So that's one thing I would caution folks against licensing, is an online store that delivers to Toronto and, you know, other places, especially out of province. Too difficult. Big challenge.
It's Chief Nadjuan. I'm going to fast forward. So the light at the end of the tunnel here is working to promote economy, to assist entrepreneurs, and we're in a really unique position as far as First Nations goes. We have an agreement with the Crown called the Coldwater Agreement, which allows us to purchase properties and have it turned without a whole lot of time and complication into reserve plan. To be a successful in any business, the old rule, location, location, location.
Absolutely.
We don't live on the 401 corridor, but we do live on a corridor that is inundated with traffic.
Absolutely.
Part of the concerns in the community are impacts of people coming into the community to purchase product. So I'm saying, let's not beat each other up over this. Let's look at the best way that we can promote and assist the entrepreneurs that are involved or in the cannabis trade, and do it in a win-win situation where their profit margin increases with the First Nations and the Cannabis Commission going forward and licensing these First Nation entrepreneurs and doing it in a way that it doesn't leave a footprint or impact what we call the reserve.
Mm-hmm.
We don't have to wait for the land claim settlement because that's, it's quite a ways down the road, because when we win, there's going to be an appeal, and then it's going to, last several more years. But what we do have is the ability to purchase land, to designated reserve lands, to have a law in place and regulations that has the feel of the whole community.
Mm-hmm.
And move on. Bob's your uncle at that point. So I think we got to get away from this feeling that we're trying to impede people from being successful. No way. I would like nothing better than to see the entrepreneurs from the Saugeen Ojibwe Nation and territory to become as successful as you can become.
Mm-hmm.
But we have to do it in a way that we take everybody's comments or contributions into consideration. So, and I think you do that by having the jurisdiction, having the law, supporting the entrepreneurs, supporting the community, and as Larry refers to often when he's speaking, is can have the community's membership, health and safety front and center.
Mm-hmm.
So I mean, I fast forwarded that a bit, but I don't think it's a long process as long as we all agree to work together. And I think if we can do that, it'll happen quicker and it'll happen with method. So, enough said. There's an awkward silence.
Well, that takes us to 8:32. I'm not sure if there's any more questions in the queue. Michael, if you could just check real quick.
There is a question from Councillor Sidnajwan. He asks, how long do you give the community to have input before a final version of the law, it sounds like? And where we currently stand, for all our listeners, is that the feedback period opened on September 4th, and it's scheduled to end on September 18th. Now, that doesn't mean that the law is finalized at that point. That's when we take the feedback we've collected and we look at it and decide what the next steps are. So the end of this feedback period is on September 18th at the end of the business day. I would ask that if you're listening in, and we all know people in the community that don't have a connection or don't have computers to access this safe online community meeting we're having, but the paper copies of the draft law and paper copies of the feedback forms are available at the band office. So either local community residents can walk in and pick up those forms from reception, or they can call in and we'll arrange to have those forms dropped off. So that will go out on our channels as well. But if you're listening in, please let those of your friends and relations know that don't have access to a computer that they can get those paper copies. Now I see Lance is asking a question. Can't we just send out hard copies? For the sake of efficiency and avoiding waste, we're going to do this on an on-demand basis. Legislation isn't typically sent out in full to every member of a jurisdiction for feedback, but members can always ask for a copy of that to come to them, and we'll satisfy those requests when they come in. We do have a few questions from the Facebook feed. I wasn't going to go to those, but I happened to bring it up, and I saw some questions here that maybe our panel could answer in short order near the end. So responding to Jessica Johnston, I hope you've just heard. All of the draft laws and feedback forms are online on nawash.ca. So just visit there to get those. So a question from Jessica Johnston. Residential areas are prohibited, so how much infrastructure is required to permit a license? Question to the panel. Or is that a question that waits for the commission to decide when they're setting the regulations?
Yeah, I think it's waiting here. I think it's certainly something that, again, I was going to get Larry to touch on this, but this is the first draft of it's 3 drafts that we'll be reviewing. Is that correct, Larry?
As far as I understand, Giwan, this is a second draft. We've done the first draft, which led into these questions here, and
Sorry,
putting that out
you're
to the
correct, yeah.
community. And the final draft is September 30th, I believe we've targeted.
Which is the 3rd draft there, yes.
That'll be
Absolutely correct. So
third and final.
3rd and final. As far as trying to answer the question about infrastructure, I mean, it's something that's clearly an issue in the community in terms of having adequate water supply, electricity needs, and improving our road system for commerce. But that's something that I believe can be addressed in future conversations at the committee level. And also, I do believe if another committee member, maybe the chief, could speak to this, there has been a conversation over land use planning. So I'm not sure if these are sort of cross-pollinated types of discussions that are happening at that level or that committee. I'm not a part of that one.
Thanks, Kuwait. So Michael again, I have a question from Randy Jones. If the commission is found to be unfair, what security is given to the individual business owner that could be directly impacted? Would we stand in front of commission or council?
So the commission makes a decision, and then there's an appeal process if the commission is not being fair in the decision making itself. But if there's sort of like a procedure, like there seems to be sort of something in the system that seems to be sort of detrimental, maybe there's a procedural impossibility that's happening because the regulation created by the commission isn't working, then that would be something that you would first inform the commission and get them to reconsider it. So there's a right of reconsideration. So an
Thanks
appeal
for-
process, so there's an appeal process. So we try to put these earmarks of procedural fairness inside of the law. So the first one is if there's a decision made that either is biased or unfair or maybe even just plain wrong, there's an appeal mechanism. 30 days must be made 30 days, or the commission can decide to go beyond that 30 days. But if the regulations, the rules themselves are unfair, then you can ask the commission to reconsider those rules.
Thank you, Sarah. And I have a final question from Jessica Johnston to Chief Najwan. She writes, I've heard attempts that purchase of land to designated reserve land is another drawn out years-long process. Six Nations businesses have had struggles against the government despite the reconciliation greenwashing. How would our circumstance be different?
That's a very good question, and our situation is different because as part of an agreement that we got in a land claim settlement called the Coldwater Agreement. In that agreement, it gives us the ability to purchase lands in the territory and have these lands that are purchased put in reserve status. And there's always a bureaucratic layer to everything, but that's in black and white. That's a part and parcel of that agreement that was signed, sealed, and delivered. That's what part of our the outcome for us was, that the ability to purchase. But there is a stipulation about how many acres we can purchase and allow to return to reserve status. But it is different from other communities. That's why I'm saying we're in kind of a good situation to purchase land and then to turn it into reserve status, to have this lands that avail themselves to opportunity for entrepreneurs. This meeting, we're talking about cannabis, but there's other forms of retail that members might want to get involved in. And so the perfect place is the Highway 6 corridor that has ample day trippers and others going up and down it. But at the same time, it allows us to finally become an active participant in economy. So that's the difference. And I would advise Jessica maybe to get a copy of the Coldwater Agreement to see where that stipulation is in it about us purchasing the property. And in fact, it was yeah, it was the OHC that was illegal in that agreement. Sarah would know more about it. Sarah might even be able to get a copy of the agreement to any interested Nawash member. Or, yeah, because it's specific to Nawash.
I have a hard copy of that agreement, Chief, and I can certainly try and get it scanned and forwarded on. It has all the maps and everything in it. But in addition to that, there's another opportunity in that lands can be purchased inside of the city of Aurelia. So it takes us into a completely other jurisdiction, but that was negotiated as part of the settlement with the Coldwater claim.
So we're running long here. We have one more question from Lance Johnston Reyes, who asks, with the community in its entirety being residential, how do applications get approved for on-reserve stores?
So I don't, we didn't have any conversations. I didn't have any conversations with the task force about any specific rules around the management of the reserve lands, around CPs and things like that. Some laws talk directly about that, eligibility, what needs to be done in order to apply, like in order to have CP land be the site location for a store. Some of the requirements are put right in some of those laws. So there hasn't been a discussion between me and leadership, but I would say that that the commission definitely needs to know about these issues. And again, if there's a barrier like this where, you know, the rule is that, you know, there can't be any cannabis activity in a residential area and the entire reserve is a residential area, then that certainly is a problem and it's something that we'll have to deal with.
Thanks for that, Sarah, and to the panel, thank you. I don't see any other questions pending right now, so I think we're going to wrap it up there. Chief or Councillor Elliott, if Councillor Saunders is still online, do you have any final comments for the audience or anyone else on the panel, actually?
No, I think this went fairly well, and again, I encourage everyone to share the video if it's on the Facebook Live. Please share it with community members and encourage more feedback. The point of the residential issue is well taken, and it's something that the committee will circle back on with the Land Use Planning Committee to see if we if those discussions are being had, and we'll have that addressed for the final draft.
Okay, if you have no further comments, then thank you everybody who attended. Thank you to our panelists, Larry Sue, Sarah Mainville, Chief Greg Najwan, Councillor Elliott, Councillor Saunders there, and we had Councillor Sid Najwan in attendance as well. Good work, everybody, and I'm sure we'll all talk again soon.
Thank you.
Jimmy Gwitch, everyone.
Miigwech.
Miigwech.
Mama P.
Mama.